Thank you so much, Wendy, my friends and colleagues in this room and in the AALS, including my executive committee colleagues, my fellow officers, and Judy Areen, our executive director, for this opportunity to serve as AALS president. I am honored and humbled. I want also to thank my spouse, Bob Taylor, for his loving support, and the superb AALS staff who do so much to assure the smooth functioning of our meetings. Wendy Perdue's theme, Building Bridges Across Increased Polarization, is not just for her year, but for our era. Today, I want to extend her engineering metaphor to discuss the role of legal education in strengthening the pillars of U.S. constitutional democracy. Is our constitutional democracy at risk? After all, you might think, we continue to have regular elections, civilian courts checking the government and deciding private disputes, strong voices of public contestation, and law schools that in recent decades have become more inclusive and encouraging of public interest and public service work. But constitutional democracy can be put in jeopardy in different ways: by a single dramatic act of rupture, or, I worry, by concurrent weakening of its pillars. I discussed three. First, law and its institutions. Second, elections and representation. And third, the knowledge institutions of which we as law faculty are a part. With respect to the rule of law, more countries in the world are declining rather than improving, especially on human rights, checks on government power, and civil and criminal justice. This is according to the 2018 Rule of Law Index, a project begun by the ABA. This decline on the Rule of Law Index includes the US, now the subject of scholarly books with titles like How Democracies Die. In Hungary and Poland, formerly independent courts have become much less so, and what becomes normalized in one democracy may spread to others. In the words of Canadian Supreme Court Justice Rosie Abela, an attack on the independence of a court anywhere is an attack on all courts. While the idea of government under law has been central to our constitutional tradition, protecting individuals, groups, markets, we are today seeing unprecedented attacks on judges by public officials. Personal attacks intended to intimidate or delegitimize judges are quite different from criticism of a court's judgment. U.S. legal institutions are under challenge from other sources. Fear of terrorism, of immigrants, has been placing pressure on the rule of law for decades. Efforts to defund legal services threaten the equal application of law to rich and poor. The rise of group hatred poses a rule of law challenge both in inciting violence and in making it more difficult for judges and juries fairly to apply the law. And the rule of law in Congress and some executive offices, meaning adherence to procedures to secure adequate information and fair consideration, has declined, notwithstanding Senator John McCain's calls for a return to regular order. What to do? One important answer is for law schools to keep on keeping on, training students in legal analysis of cases and statutes, in how to design fair processes, in understanding both sides of an issue, in appreciating the role and limits of courts, and in lawyers' obligations to clients and the public good, encouraging speaking up for justice and against departures from law. But we also might examine our curricula to see if we're providing students with the knowledge that supports good legal process in all parts of our government. Our students, after all, will not only be lawyers and judges, but in disproportionate numbers, they will be, if past is prologue, our legislators, local, state, and federal, our governors, our presidents. In addition to lawmaking and law-applying norms and institutions, then, a second pillar of constitutional democracy is fair voting and representation, with law laying down rules in advance about who can vote, for what candidates, for which offices, and perhaps for the powers of those offices. But law can be used to obstruct as well as to support democracy. as with the recent wave of franchise restricting laws. Carol Anderson, in One Person, No Vote, calls attention to the interacting systemic effects, for example, of new voter ID requirements and closing regional motor vehicle bureaus, making it harder for poor people to obtain now needed forms of identification. Voter suppression is not legitimate in a constitutional democracy. As legal scholars, we can explore an unconstitutional state of affairs, to borrow a phrase, arising from such systemic efforts and how they threaten representative democracy. As legal educators, we should ask, are we doing enough in our teaching and scholarship to explore the importance of fair electoral institutions and the norms of political reciprocity on which a decent democracy must rest, where having opposition is understood not as criminal, but as democratically necessary, where those in power today must govern and compete knowing that tomorrow they may be out of power. Survey data suggests that too many are losing faith in democracy. Increasing numbers do not think it is important to live in a democracy and support having a, quote, strong leader who does not bother with elections, and even believe it would be a, quote, good thing for the army to take over. Are failures of representation responsible? We provide students with thick, normatively contested ideas of what it means to be a good judge, but our law school curriculum has focused less on the role of a good elected representative, leaving a normative void that reinforces a perhaps overdetermined downward spiral in public officials' conduct. Responding to the multiple pulls of constituents, party, and policy is truly hard in ways we too often ignore. Perhaps the first-year curriculum should consider basic questions about representative democracy and its alternatives. Let me turn to the third pillar, what I call knowledge institutions, colleges, universities, law schools, a free press, and NGO and government offices devoted to gathering data, disseminating that data to the public. Totalitarian governments require their people to live a lie, in the words of Václav Havel, a Czech writer and statesman. In a true democracy, knowledge creation and diffusion hold a central role, so that decisions on who to vote for, what to preserve, and what to change can be based on accurate understandings. Self-governance requires informed voters whose opinions rest on shared knowledge, not truthiness. We, as law faculty, are a central part of this epistemic base. George Washington, as president, argued repeatedly for a national university to educate citizens in knowing their rights, knowing the law, knowing how to evaluate their representatives, and understanding government. We're better than in our law schools. Higher education, of which we're a part, faces real challenges. There's a new partisan divide about whether higher education is good for the country. In 2017, 58% of Republicans responded negatively, while 72% of Democrats responded positively. This gap, if it continues, threatens the public base of support that our institutions of higher learning need. Accessibility, especially for first-generation students, is an urgent question. A sharp drop in foreign student enrollment diminishes the educational richness of our campuses. Many believe there's a need to reinforce norms of tolerance and reasoned disagreement in public contestation. Other challenges confront the press, which plays a key role in democracy by investigating and reporting on matters of public concern. In what Martha Minow calls the changing ecosystem of news, social media may spread inaccuracies. Rumors go viral. Extreme positions cascade. Fake news spreads. Foreign powers use cyber tools covertly to influence voters with disinformation, which take time and resources to uncover. Yet reputable news sources face increased financial constraints. Investigative journalism has been losing its institutional infrastructure for decades. Verbal attacks on the press escalate, and journalists are increasingly targeted by violence in Annapolis, Paris, Istanbul. Other knowledge-generating organs include some government offices. The census, required by the Constitution, recounts population every 10 years so as to fairly allocate seats in the House of Representatives, a very close connection between knowledge and representative democracy. Many federal entities exist to gather information as a basis for policy. The National Oceanic and Atmospheric Administration, statistical offices, and the Justice and Agriculture departments, the EPA, and many others. But if government offices are not reliably gathering data or making it public or prohibit their scientists from participating in academic events, the ability of those entities to provide epistemic support for our constitutional democracy declines. What can law schools do to further explore knowledge-creating institutions' relationships to constitutional democracy? First, consider how law sustains those institutions. Think of legal protections for the press or for academic freedom and scientific inquiry. Second, explore how law's development is itself dependent on knowledge-producing institutions. Consider Ida B. Wells, a journalist and activist born in slavery who, despite death threats, gathered data, lots of data, to campaign against lynching. The way to right wrongs, she said, is to turn the light of truth upon them. Law reformers have a real stake in protecting knowledge generators. So we might ask ourselves and our students to examine both rights and the institutions that separately and together advance knowledge. We might bring together different legal areas, not just free speech or higher ed law, but corporate law, antitrust, national security law, to better understand the larger legal infrastructure within which our knowledge institutions function. In closing, let me emphasize 2 points implicit in what I have already said. First, in trying to strengthen pillars of democracy, law schools, through scholarship, classrooms, and clinics, could improve the study of elected officials, their roles, our aspirations from them, how they differ from courts. For example, we might ask, do principle and compromise play different roles for a judge and a legislator? Judges should aspire to principled decision-making under law. But should our elected representatives at times aspire instead to make fair compromises? Just an example. Second, institutions can only do so much. Character and attitude matter. Perhaps we need to model and encourage in our students forms of lawyerly civic virtues that support constitutionalism and democracy, including open-mindedness and tolerance, integrity and courage, as we heard, or some of us heard in Justice Cameron's talk earlier in the week. I had the great privilege to clerk for Justice Thurgood Marshall, an exemplar of moral and physical courage over and over again in his legal work. Lesser known, but emblematic of many government lawyers with integrity, is Louis F. Post, a Labor Department official who, in 1920, refused to carry out mass deportations of the immigrants swept up in the Palmer raids because of his knowledge of the law and the facts, and despite being denounced and threatened with impeachment in the House. As these stories show, positive change can happen and threats to basic values resisted. Can we help foster the courage to stand up for equality and against lack of respect for the human dignity of any of us? Can we foster the courage to make compromises that enable government to work? What courage and integrity require of lawyers in different contexts is, of course, subject to good faith disagreement. Law schools are great places to have these debates in our scholarship and our classrooms. If not there, where? Today's challenges to constitutional democracy, disrespect for law and its institutions, for elections and representatives, and for knowledge-producing institutions can be mutually reinforcing. but so too can strengthening those pillars. There's reason for hope. Surveys show that college graduates of both parties feel positively about their own college experience. The public expresses willingness to spend more tax dollars on higher education to improve accessibility. This is particularly important. The AALS's Before the JD study found significant barriers for first-generation college and law students that will take resources and commitment to overcome. Our study also found that students are considering law school for quite public-spirited reasons. So I have every confidence that law schools and the lawyers we produce will continue to be key supports for American constitutionalism and democracy. And I look forward to hearing from all of you more thoughts on how we as legal educators together can help strengthen the pillars of constitutional democracy. Thank you.